This meeting of the Ethics Commission will come to order. We'll have a roll call.
Ms. Olszewski? Here. Ms. Hodge? Dr. Dakey? Mr. Blanchett? Here. Mr. Coy? Here. And Judge Wenzelman? Here. We do have a quorum.
All right, having a quorum, we will go to the second point on the agenda, which is public comment. Does anyone in the massive public wish to speak? No, okay. We have a discussion item here, Robert's Rules of Order. Oh, excuse me. Does someone move to approve the minutes, which were sent out to us? Thank you, Mr. Blanchett.
Second.
And second from Mr. Coy. All in favor, aye? Aye.
Aye.
Any opposed? Then the minutes are approved. Now we can have the Robert Rules of Order discussion.
Hi. Good morning, all. This is going to be a brief just reminder about Robert's Rules of Order. We discovered that when I was going through the meeting minutes from the past few times we've met, it was a challenge sometimes to distinguish who's saying what because there's a lot of talking over one another. Which, you know, I get it. We're all kind of trying to have our input and all that, but the purpose, or one of the purposes of Robert's Rules is so that doesn't happen.
Excuse me, can we recognize that Dr. Dakey has joined us?
So I just asked this commission only because of the technical aspects of the things we talk about sometimes, that the chair recognize you before you speak. That way we understand who's speaking and what they're trying to say. It's just a pain for Diane and I to go through the minutes and try and figure out who's saying what and when. So I would just ask that we be a little sensitive to that while we're working through
You didn't know we were doing that on purpose?
If you're doing it on purpose, I can control that, but he's making life a little harder. So
okay, we will try to.
And just also remember that just because of the small nature of this body, we've been advised to leave all the microphones on, so even side comments do get picked up and will be attempted to put in the minutes. So that makes life a little more challenging too.
Yes, all of us like a challenge.
We all like a challenge,
Right.
especially those in the legal field, right?
Thank you, and we will try to do that to be a little bit more aware of letting everybody know.
I recognize it's a little bit more informal in the setting just because of the small nature, but just be conscious of that.
Okay, the next item on the agenda is ordinance revisions.
All right, so I sent around a PowerPoint. I think we have it pulled up or ready to be pulled up here. I made the basic edits that I understand Judge Wenzelman's raised a couple times, very easy stuff that I could go through and relatively straightforwardly change. That doesn't mean I've encompassed everything this commission has discussed or Wenzelman's comments throughout this process. It's designed for discussion, but I figured it was easier to have something that we could all edit as we go here. It's literally just our ordinance copied and pasted into PowerPoints, and then I've highlighted the edits that I've either recommended or we've misspelled something, you know, little things like that too. So my proposal is just to go through it slide by slide and go through it kind of with a fine-tooth comb and see what your thoughts are. If we want to change anything, the judge can of course weigh in and go from there. So
I do have one question.
Sure.
The first line where you've struck advisor, which is what we want to remove, but according to the agenda, it was going to go to ethics administrator.
And that's, like I said, I've just gone through and made the edits that I understand we discussed.
Well,
I change to administrator, we can change it to administrator. I've also not changed it throughout, only because of this very reason, right? I didn't know if you want an officer or administrator. I thought investigator was thrown around at one point. You know, whatever you guys want to amend it to. I was just suggesting officer because that seemed to be the consensus from last meeting.
Well, let us ask Judge Wenzelman what he feels would be the right thing to do.
Well, excuse me. We're looking through some of the suggested revisions. One of the things that got taken out was the review of statements of economic interest. I mean, when those are in there, then that was kind of like, all right, so it's kind of something more than just a straight investigative type of process. Right now, I think that's primarily what it is an investigative.
Well, do you want to be administrator or officer?
Officer is fine with me.
Fine with me.
Question is, it would be fine with the next person, hopefully. Yeah, I think that works.
Yeah, from my perspective, it's just a title, right? The concern was the word advisor implied legal advice, and I understand Judge Wenzelman, was sensitive to that, and I understand his reasons. So past that, I don't really think there's any real significance.
Right.
It's really just what you want to be addressed at.
I didn't see that
Microphone on.
officer actually changed to officer.
Correct, and you'll see that throughout all the rest of the
what
slides.
number
I
is that?
just changed it on this first one because I wasn't sure which one it was going to be, so I didn't want to make life harder. So if we want to go with officer, we'll go with officer, and I'll go
Officer,
through it. And,
fine, seems like it's fine with the board, so.
all right. So the next section is subsection C here, which basically says the ethics officer now wouldn't be required to have a law license, and if any questions of a legal nature come up, our office would be asked to render an opinion in writing. Any questions, concerns regarding that, or we can move on?
Does that answer your? Yeah.
Okay.
Does it seem like that's it?
Well, again, in light of what just happened the last time around, I don't know if we need to put in some type of caveat or escape clause or whatever when there's a question as to whether or not it would be difficult for the office of the state's attorney to be able to give opinions in that. And I don't know if that's anything that we can really address right now, but it's, again, we saw it when the one complaint that we did have recently.
Right. Maybe eventually we can add a clause that says that should the problem not be able to be handled by the state's attorney, we would require going to another legal entity.
So after the state's attorney, fourth line there, one way to address this concern would be comma or appropriate legal counsel, comma, to issue a written opinion. That way, if for whatever reason our office can't do it, as we discovered last time,
Mm-hmm.
we can go to either the appellate prosecutor's office or private counsel or whatever the case may be and go from there. Just to add that caveat.
Excuse me, it's me.
Busted.
But a reminder to the rest of us to turn our sound
Yeah,
on.
right.
Stays on much longer, we're gonna get up and start jigging.
Yeah, I was gonna say.
That's why I didn't recognize it, it's new.
Oh.
Excuse me. Or appropriate legal counsel is what
Right.
we're adding, right?
So as we go through this, I should have said this at the top. Anything that's not addressed in what I've added to the slides, I would recommend you do a vote on. And then at the end, we'll just say all the edits in the PowerPoint. We'll do an omnibus motion at the end, and then we'll go from there.
Very
Just
good.
to cover the procedural aspect. So if that's an appropriate revision, I would recommend you call for a motion to add that in.
Now,
Correct.
not at the end,
Yes, no, throughout the process.
throughout the process.
Yep.
Okay. All right, we need a motion to approve this change or appropriate legal counsel, adding that in section C. Mr. Coy, second? Mr. Blanchett? All in favor? Aye. Opposed? Thank you, then that change is approved.
All right. Is there anything with this section, A, B, and C, that we want to discuss before moving on? And we can always come back, because obviously these do interact quite a bit,
Yeah.
different sections of the statute or the ordinance. All right.
Actually, yes. On part B, when it talks about the county board being able to remove without cause, why would that, why is that there? Particularly the county board could remove the now officer without cause?
So that, I can't speak for the reasons the county board added that language in when we first passed this. I don't know, but if you want to recommend to change it, we can recommend to change it. Obviously, needs to go to executive and county board again, so they might deny that request, but I can't speak for their intent.
I was just asking for clarification. Is that standard kind of thing to put into a?
My recollection of when we went through this the first time was we did go to other counties' ethics codes and pull kind of standard language, so I imagine that's probably where it came from.
I'm okay with
But
it.
it's speculation. I don't have
Yeah,
that
okay.
definitive for you.
I do too have a question about that, in that, so it means Andy Wheeler can just say, I don't like so-and-so, and he's gone. Is that essentially
As
what
it sits right now, that's the way I would interpret this, yes. But it wouldn't be just Andy Wheeler. It would be the full board.
with the advice and consent of the county board, okay.
Right.
With or without cause?
So it would still have to have a vote of the full board. It won't be just one individual saying, I don't like you personally, or for whatever reason, and you're done. It would be the whole board would have to vote to remove.
And would the entire ethics commission be notified of that possibility before it happened?
The ordinance doesn't say it would be required. I would imagine common courtesy would play in here, but it doesn't require it. So, at this point, I would defer to if you want to change it or make a recommendation to change it, or we could move on.
You know, I understand being removed for cause, but without cause. But then if you open up that, then you're gonna have to define what cause means, or not necessarily.
Cause, I believe, would be interpreted by the county board.
Oh,
Right.
okay. I actually be more comfortable if it was with cause.
Okay.
What? Any other?
Well, and I'd like to have it say that the ethics commission would be advised before the action was finalized, so that if we felt that there was something we should say in defense of,
One thing the ordinance does say, it does say notice to the chairperson. If you look at what just after the without
a
with or
notice
without
to
cause,
the chairman
so the chairperson would be.
and the ethics.
So if you want to change that
Oh.
to every single individual at the commission, that would be another suggestion we could make.
The with or without cause almost sounds like an employment contract, because I know what that's.
Probably where that
Yeah.
language came from.
Yeah.
Probably.
I would like it to say with notice to the ethics commission.
Okay. So would you like to make that motion, Madam Chairman? Of what exactly you'd like to read?
I would like it to say by notice to the ethics commission, taking out
Chairman of the commission?
chairman of the commission and leaving in the ethics advisor or officer. Yeah, and then I would like it to say at the end, before final action is taken. So it would read, I move that we make a change that would say, by notice to the ethics commission and the ethics officer, by certified mail, return receipt requested before final action is taken.
Okay.
Are we going to take that without cause, or we want to leave that?
I would like to take out with a cause.
Okay. So add that
Okay.
to your motion, and you need a second, and we can vote on it.
Second?
Thank you. Any discussion? All in favor?
Aye.
Aye. That passes. Dr. Dickey was the second.
All right. Are we ready to move on to the next section? Yeah. So on this
Yeah.
one, I just simply took out the second responsibility of the ethics officer now, which would be reviewing statements of academic interest and disclosure forms of any person subject to this article. The reasoning was, I believe, the county clerk is already statutorily required to do that. If he has any concerns, of course, he can come before this commission and make those concerns, or the appropriate state agency. It seemed a little redundant, probably just a carryover from another ordinance as well. And then I believe Judge Wenzelman voiced some concerns about not receiving those and not having had the opportunity to review them as well. So for the sake of just expediency, I removed it. Of course, we can leave it in and make that a requirement. I just wanted to remind myself to have a discussion about it.
I think it's fine as it stands.
With that strict.
With it stricken.
With it stricken,
Okay.
yes.
All right. Any other commentary on that? I don't want to just listen to one voice. Okay.
Yep.
I made no substantive changes here at all, so any recommendations there, or we can move on.
No, I think that's fine. Any discussion? Anybody have any ideas about that? Otherwise, it stands.
The next few slides, I don't anticipate much discussion. This is just how the commission was created, the terms of office, and that no more than 3 out of 5 members can be of one political persuasion. I don't recall any major discussion or problems with this section of the ordinance, but I
Right.
wanted to include it just in case.
If no one has any additions or subtractions, that'll stand.
Okay.
Oh, back in 253, let's see.
Now we're on section 254,
Well,
removal.
I was looking at 253. Does it still say about three commissioners? Doesn't it?
It should say 5, right?
Yeah. Back in 253, because it talks about 2 commissioners, 2 year, and the third commissioner will serve a 1-year term.
Okay.
So this is a function of how things get amended throughout the legal process, and I'm sure the judge is laughing at me to my left here. But if you notice initial terms, we started with 3 members.
Right.
So this is
Okay.
right when
Okay,
we
I see.
reiterated
I
it.
see what we did. Okay.
And then we added the 2
Okay,
additional
got it.
members in C.
Okay.
So you kind of have to read them together and add them
Okay.
together.
All
I
right.
know it's not
Well, it says
The
5
clearest,
in the
but-
initial creation paragraph,
Right.
252.
Okay,
Yeah.
got it.
right. So it's just a function of how we had to go through it. We've all been there. That's why state law is what state law is sometimes, right? All right, 254, I believe we're on. Having read this just now, it actually kind of echoes the concern that Dr. Dakey raised about with or without cause. Because if you'll notice, it says, may remove a commissioner for case of incompetency, neglect of duty, or malfeasance in office. Those would be the reasons that would be justifying someone being removed. So, in a way, that without cause we took out previously seemed to be null and void,
Okay.
but
Right.
I appreciate it for
And
clearing it up purposes.
but the only notice is to the person being removed, not to the ethics commission.
Correct, but as we added before, now you'd have notice to everybody on the commission, certified mail, under the previous section. But we can add it here too if you feel more comfortable having it in both places.
I believe the previous section only dealt with the officer.
Exactly.
Did it?
Yes. It was only for the legal officer, or whatever we're calling him.
Oh, you're absolutely correct.
Yeah.
Thank you for calling me out on that.
So the chairperson of the county board, with the advice and consent of the county board, may remove a commissioner in case of incompetency.
Right.
after service on the commission, on the commissioner.
Commissioner in
and-
question, I believe, is
And
what,
the
how I would read
ethics
that.
commission.
If you want to add that in, we can add that in.
I think that, certainly we all show up for a meeting and
Right.
so-and-so isn't here,
That's
it'd
fair.
be nice to have
Yeah.
known why.
Completely fair. Completely fair.
So I would say a service on the commissioner and the ethics commission. That's what I move. Do I have a second?
Second.
Dr. Dakey, thank you. Any discussion? All those in favor? Aye.
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 All right.
Opposed? None. Okay.
Any lingering concerns here, or are we ready to move on? I don't mean to force us if we
No.
have any questions, so I don't mean to
I think that's all right.
rush us along. So the only thing I added here, based on some discussion we had with Judge Wenzelman, was taking out the word attorney in subsection 2 and replacing it with office, department, or bureau. I struggle to find a situation where an attorney be the prosecuting authority just independently. Usually they're through a commission or a department or some sort of a governmental agency, either our office or the AG or places such as those. So the word attorney seemed clunky to me, so I just wanted to clarify that point. But
So the commission shall, however, act only upon the receipt of a written complaint.
correct.
So that means that we can't see a problem and talk about it ourselves.
Well, I see no reason why a member of the commission can't independently file a complaint if they notice something untowards in any department in the county. They would have probably some issues with recusal and bias and all that when it comes to hearing the complaint. But if you see something, there's no restriction on you saying something. I think the concern there is the Spanish Inquisition effect, right? You kind of go through each department and looking at one things from one perspective, right?
Like the grand jury.
Kind of, yeah. I think that's the concern that this was originally intended to address. Basically, giving you the authority to act once something is addressed directly to you. I don't know if you have anything to add there. Yes, sir. Are you mic's on? This is Mr. Blanchett.
Yeah.
Yes, Mr. Blanchett.
What I'm seeing here is, if there's a complaint, who is going to notarize it? They said the complaint must be notarized. So if I get a complaint from somebody, do I have to tell them you got to get this complaint notarized before I can look into it?
Does our form that we put together, excuse me, Judge Wenzelman, does our form provide for notarization that we put together?
I honestly don't recall. Diane, do you recall what was on the bottom of that?
I don't remember there being any discussion of having that notarized.
No, I just read it here.
Yeah,
Yeah,
no,
it's-
Mr. Blanchett's correct. It's in the ordinance as written right now. I'm trying to recall if it's on that form we put on our website, and I don't recall off the top of my head. So I think Diane's gonna run upstairs and just double check that. Diane, are you a notary?
Yes.
So I guess that is a potential if someone can't find a notary for whatever reason. There's several in the
Yes, but
administration
why
department.
why make a notarization
I understand your concern.
onus on a complainant?
the form here?
Oh, you got it?
Well, I got it from.
Steve just got it too.
Yep, that would be it. Is it last page presumably, right? No,
How many pages are there? Two, just the
just the two, I think.
Yeah, so there's nothing on there for notary.
There's nothing on there
No.
for notarization.
Then I move that we remove notarized. Now, if we want to say that whoever accepts
Yep.
the complaint should notarize it, but
Witness?
Or witness. or witness.
We can do that.
What?
Diane's suggestion
Yes, I'm sorry, I didn't hear that.
was instead of notarized, she said witnessed. So that we would probably have to add another signature line on the bottom page just to have someone else sign it, but that would be a simple fix.
Upon filing it.
Correct.
Okay.
Yeah.
So the motion then,
Don't let me
Mr. Blanchett, is to remove notarized?
Right.
and replace it with witnessed or not replace it with
And,
witnessed.
no, remove notarized and add witness.
All right, the motion is to remove notarized
You already changed it.
and in its place, put witnessed.
And again, Judge Wenzelman, and I assume the purpose of this is to make sure that something isn't sent in just by, and they supposedly have somebody else's signature on it. It's not gonna completely eliminate the possibility, because, you know, if one person is gonna do something like that, he can probably find another person to sign it to make it look like it was a witness too, so. I
Or
guess-
should the witness be the person that receives the complaint?
I'd have a hard time suggesting that in case the person receiving the complaint is the one who's being complained against. I'd have a hard time recommending that. That's not pointing any fingers at the hand, but
I guess the benefit of having it notarized, again, Judge Wenzelman, I'm sorry, would be to ensure that there's a signature on this complaint, somebody notarizes it. If the notary's doing their proper job, they will look to verify the fact that the person signing is who they say they are. So there may be some benefit in having it actually notarized.
Let me ask you this. If I file a FOIA, do I have to have it witnessed or notarized?
No.
Then why would you want to have this?
well, I think a FOIA and a ethics complaint are very two different animals, right? A FOIA is just a right under the law to receive documentation from a government agency. This has the potential to seriously disrupt an individual's life.
But would we not, upon the receipt of a complaint, we wouldn't just start hearing it or turning it over to the legal advisor or whatever?
Absolutely not. But that doesn't prevent the ethics officer from making an inquiry, making sure that, you know, witnesses are factually alleging certain things. All I'm trying to say is when an ethics complaint gets filed, there is a high chance that an individual's life will be inconvenienced is the worst that would or the best that would happen. Disrupted,
No, I understand
whatever
that.
the right word is.
But before you would begin, you know, if I get a complaint like against so-and-so, wouldn't the first thing to do would be to contact the complainant and ask if they are making this, and before you would go on, I don't know. I mean, if the complainant is going to get it witnessed, he could go next door to his neighbor and say, witness this, you know.
Well, that's the difference between witnessed and notarized, right? A witness,
Yeah.
you're absolutely right. I can go to any friend who I've known for years and just have them sign it, and they're not even going to
And
read
I
it.
go to any
A
friend I
notary
know.
is going to double check the identification of the individual who's alleging to be the person signing it, and ensure that they're actually that person, and off we go, right? My
That's the distinction in that.
Yeah. So,
This is Don Dakey.
I
To
would
me,
withdraw my motion then to
Okay.
change it.
all right. Mr. Blanchett withdraws his motion and we leave notarized. Right?
yeah, I'm more comfortable with that. I think it just makes it more serious in nature. This
Right.
is a procedural
Mhm.
issue, so
Absolutely.
I would endorse leaving it as is.
Okay.
So, again, Judge Wenzelman, that will require a amendment to the form then to get that changed, so there's a place for notarizing.
easy fix.
All right. It has been advised to change the form of the complaint, to add to it
A
a
notary,
notary
section.
line. Yeah.
Yeah, it's copy and paste. Easy enough to do. Anything on this slide before we move on? Okay. Continuation of powers. I didn't change anything on here. Is there any commentary on this section?
When it says compel, that means
Require subpoena power, basically.
subpoena power, okay.
I like saying what it is, subpoena power.
Any more
I was thinking my
suggestions on this section? If not, we can go on.
it's kind of it's like a quasi. No,
We can go on.
okay. I didn't change anything on the complaint filing procedure. Obviously, I'll have to change advisor to officer, but we knew that.
We could here, if we wanted to add the notarization part,
If you want
if
to add it in, that's up to you. I mean, it's already going to be a requirement, or was
On
already
that.
a requirement. We're going to.
that's sufficient
on.
then.
Yeah.
Okay.
Yeah.
If there's no further discussion about that part, we'll go on to the next.
This is just a continuation of the previous section. I made no edits based on previous commentary, but
Ethics officer.
right, like I
Yeah,
said.
okay.
Yep, I'll go through and make sure that
Okay.
that change applies throughout that one.
If there are no other discussion about this part, we'll move on to,
Judge Winselman, again, not really specifically on this, but looking at this, talking about a complaint against the various, whatever covered under the statute. When I was going back through it while we were going through the prior complaint, it seemed that the only areas that are specifically in the statute are one, political activity, and two, what was the other one? I can't even remember that, but there was only like two things. Yeah, gift ban.
Yep.
And then there was a question, as far as any specific reference in the whistleblower that is within the purview of the commission. But is that essentially the only areas that the commission is being looked upon to look at? Again, political activity, gift ban, and whistleblower, which I guess could be almost anything and everything.
So at the beginning of the meeting, we went offline and discussed that. Certain things that I know we've discussed in the past, I didn't feel comfortable recommending changes only because there was a moving target or whatever. And this was one of those areas. I did make some changes once we get to the whistleblower section of the ordinance at the end that says a whistleblower complaint, I think was the language, can be sent to the state's attorney, the auditor, the department head, and the ethics commission, which would imply that you have anything that would fall under whistleblower. That's my one change that I made in this topic. That doesn't mean it is the only change we can make if we want to clean this up. I just didn't feel comfortable doing that without some input from this commission.
Okay. So we'll eventually get to a spot to.
And we can come back to it if you want. I mean, I heard that concern and it's in there, but I didn't feel comfortable making the changes throughout without discussing the house.
all right, we can come back to make any other discussion of this section. We can go on to procedure. $257. I thought that was
257. We get there? This section basically says what Judge Winselman is supposed to be up to, at least from the onset of a complaint. I didn't make any changes, so.
Do we need to be more specific about what promptly is? Or not?
My personal opinion about how Judge Wenzelman conducted himself in the previous complaint would qualify as promptly. That doesn't necessarily mean we can't quantify it a little closer if that's the commission's will, but I also hesitate to say it should be within 30 days or it should be within 2 weeks, just because the nature of the complaint and frankly the judge's schedule might prohibit that. But we can tighten it up if that's the commission's wish and make Judge Wenzelman's life a little more difficult.
Give him just cause to remove me.
That too. That too.
All right, if there's no further discussion of that particular item, then we'll move on to,
I would just simply say promptly, I think, means don't sit on something for forever without some just cause or reason, and I think
Yeah, there were issues that were involved that basically took us a while to be able to do it because.
that's right,
The preliminary issue on the last complaint was who was gonna give us.
Legal
exactly,
assistance.
exactly. I just only was referring to promptly as applying to starting, you know, so it didn't sit on somebody's desk for a year.
Right.
right, and I think it's sitting on someone's desk for a year. I think that would not be prompt.
No.
I mean,
Well, it just gives the person filing the complaint
a little
a
clarity.
method of
Yeah.
saying this was not prompt, but
Yep.
okay. We can move on.
Okay. So in this section, I removed, based on commentary from Judge Wenzelman, that part of the ordinance that requires that this commission forward any complaint to the appropriate legal authority on its own volition. Reason being, I think there is no requirement to do so, and just by the very nature of this body doing it, they might imply some sort of sense of guilt. And I don't feel like that would be an appropriate thing to tarnish the reputation of this commission. Just by saying the Ethics Commission is forwarding a complaint to the Attorney General, for example, that in and of itself has certain implications that I don't think are something we want to foster. Just because you're submitting it doesn't mean you agree with it, but the implication might be otherwise.
So what then is the procedure?
So the procedure would be the individual who files the complaint would have to go to the appropriate body and file the complaint in that appropriate body.
Who tells them what that is?
And here it says, when the ethics advisor shall notify the complainant of the proper authority with which the complaint should be filed.
Okay.
Which that I don't see any issue with, right? It's purely an advising statement of this is not the appropriate place, but this place is.
Okay.
And if the person wants to proceed onto that other body, they have every right to do so. I just don't see a need for this body to be the one to forward the complaint.
This is Don Dake. You have on a clarification. What does that second line there mean by both personal jurisdiction?
Do you want to take this one?
Go ahead.
Throw me under the bus. So it's a term of legal art.
Okay.
A administrative body or a judicial body must have two things in order to proceed. They have to have personal jurisdiction and subject matter jurisdiction. Personal jurisdiction just means that the body has the authority under appropriate law to hear the complaint as it applies to this person.
Okay.
So, for example, if a complaint was filed about someone who does not work for the county, most of the time that would be inappropriate in this
Okay.
context,
Mhm.
right? And then subject matter jurisdiction would be if someone committed a crime. Again, that would not be for this, but it would be for the state's attorney and the police to investigate and proceed if that's necessary, right?
Okay. Thank you.
Thank you.
It's just a term of art.
Any other discussion of this section? If not, we'll move on.
Took the bar a while, thanks. I made no edits to this.
No.
Seems like the judge has something wants to say though.
Appropriate ultimate jurisdictional authority. I didn't have a chance to go back and see who are we actually describing there. I think there's a few more places where I saw that pop up.
Ultimate jurisdictional authority in writing that a complaint against this.
Is that like the boss, the supervisor, or?
Well, excuse me, what are you asking? Is
The line, again, Judge
the
Wenzelman-
appropriate ultimate jurisdictional authority?
Right.
My take on how that reads, and please feel free to disagree with me here, Judge, but my read of that is a callback, if you will, to the previous language that says this body will forward the complaint to the appropriate prosecuting authority. I missed it, so I think that would be, if we're going to take that section out as we already have, this would probably be something we should strike as well. That's the way I read this. Do you?
That's I didn't know if it was talking about, giving notice to an individual's boss.
Boss or supervisor.
Right.
Whatever, yeah.
But again, it probably is making reference back to
I think.
the other entity that you would be referring the complaint.
So my recommendation then, if that is the way this commission reads it as well, is to strike after the parentheses and the appropriate ultimate jurisdictional authority.
Wait, so this is after the commission or the jurisdictional investigation says,
Correct.
yes, the Ethics Commission has this particular case and it's appropriate for the Ethics Commission to do it.
Correct.
The ethics officer would notify the person subject to the complaint,
Correct.
and the appropriate ultimate jurisdictional authority of that person that the complaint was against.
Correct.
And if we were going to go on with the investigation, why wouldn't we notify the person who was responsible for the complainant's activity? It's his employee, his or her employee.
Your turn on the boss.
Well, again, and that's what I guess I'm still trying to sort out who they're actually referencing there with that language.
Okay.
Again, that's my understanding. Some of this language was taken from some other ordinances. Therefore, their definition of the ultimate jurisdictional authority might be in another ordinance that we don't have incorporated here. But if that other ordinance basically was talking about the person's employer,
Yeah.
then certainly I think that can be corrected by basically saying, we're going to proceed with the investigation. You give notice to the respondent and their employer. That way you're, or supervisor.
Supervisor,
Yeah.
yeah.
And that way they're aware of the fact that something is pending with this individual. And I
So-
think that might be what the purpose of that is.
So it would be removing
Jurisdictional.
appropriate ultimate jurisdictional authority and putting appropriate supervisor.
I'd recommend the term department head,
Okay.
but basically I think if you've hit on the correct thinking as we've teased this out a little bit.
So we would be removing ultimate jurisdictional authority
And adding in,
and leaving appropriate department head.
correct.
That a motion from you?
I don't think we can do that.
Yeah.
Oh, all right.
I'll make the motion to change.
Mr. Blanchett? Yes. To add in, take out ultimate jurisdictional authority and add in department head.
And Dr. Dakey will second.
Thank you, Dr. Dickey. Any more discussion? All in favor?
Aye.
Aye. Opposed? No. Okay.
All right. Is that all you had on that one? Okay. We're ready to move on. All right. Get yourself over to that. Get myself turned around one second.
No, it's working out if you just do it flipping.
Yeah, I'm throwing this around now. There it is.
You did not change anything in this?
I did
section?
not, no.
I guess again, Judge Wenzelman, just have a question as to, is there statutory authority that gives an ethics officer the power to compel testimony under oath?
Does that relate back to what I was asking about subpoena authority?
So the subpoena authority, the judge and I spoke off mic here, and subpoena authority is kind of the way to think about it. I don't know if it's an actual official subpoena, like you would in a court case, but it's a similar tool.
You can have an unofficial subpoena?
The word that we were talking about at the time was compel.
Yeah.
That's a little softer than I think subpoena would be, because a subpoena comes with the authority of a circuit court judge or an associate court judge, and by extension the powers to hold someone in contempt or to
Mhm.
all that kind of side stuff. You don't have that sort of authority or power, so that's why I'm saying subpoena is the way to think about it, but it's not quite the same level of strength that a subpoena would hold. Here, I've already blanked on what the question was. It was compel under oath was the concern, right?
And I guess, not to take it, or maybe to answer my own question, I guess it's here is I could send out notice to someone, tell them I want them to come forward and testify under oath. If they refuse to do it, then I guess we would have to petition the court,
That would be my understanding.
and then the court
Okay.
then would make a determination whether or not we have the authority to compel their attendance.
That'd be the way I would read it too. Ultimately, you're not a court, but
No.
we can always, ask the appropriate court to grant us powers if we have some sort of issue. So I think the judge is correct.
Okay.
I think.
And you would assume that if somebody was making a complaint, they'd want to come forward and talk about it.
Correct, but this does not just apply to the person making the complaint. This would also apply to any witnesses.
Okay.
And in certain situations, I would imagine a witness would be predisposed not to come forward
Okay.
under their rights, under the Fifth Amendment, and all that, right? So.
Mel Blanchett, I have a question. Are all the county employees, do they all belong to the union or just part of them? Are they all unionized?
No. I can go specifically which departments are unionized if that would be helpful, but the short answer is no.
They're not
No,
all
not
unionized.
every single department is unionized.
That's what I was wondering.
And there's also sections of our county that a certain part of a department is unionized and others are not. So.
Thank you.
Any other discussion of this section? If not, we can move ahead.
Okay.
There's no changes that you've made in this.
Correct.
Judge Wenzelman, I have a question. Number 3, again, that we're at a stage where conclusion of the preliminary investigation, I issue a written summary report delivered to the chairman of the commission, the complainant and the respondent. And then they're suggesting that I make I could make a recommendation for corrective or disciplinary action. I guess my concern is, it's almost like, all right, this is my investigation, you've done something wrong, this is how it should be corrected. It's almost like I've absconded the whole process.
Judge and jury?
Yes, whereas I'm thinking, I'm not, I would think ultimately you could have a process, we make this original referral, maybe after discussions, you come to an agreement that, yes, something needs to be done, then maybe you could ask for input from myself or whoever's in this position as to recommended corrective action. But I guess I have a little bit of a problem saying, this is my preliminary investigation, and because of it, this is what should happen. Again, it's like I'm circumventing, and because if the person rejects it, then it's going to go to the next stage for a full hearing. But to some extent, I maybe have foisted upon the commission, this is where we're ultimately going, and I don't think that's what my role is. That's my concern.
Would it be that
Fair
you would bring your recommendation to the commission for discussion and then?
Well, I mean, that's an option, or you could, basically, I've made the preliminary investigation and I'm recommending, let's see, we're description of the acts, finding of the ethic as to whether reasonable cause exists. So I found that reasonable cause exists. So then I guess what I would think you would want to occur is a discussion by the commission. You know, they could maybe contact the individual or their attorney and say, you know, we think we need to discuss this because we're going to have to proceed to hearing. Are you amenable to working out some type of resolution to the issue?
Similar to a plea deal. Sort of.
Right. And if not, and if they say yes, then the commission could presumably ask myself or whoever's in this position, what are your recommendations as far as corrective action?
What do you suggest should be the change?
Well, now that I've kind of outlined my concerns, I think Graham should go back and rework this area. No.
Who has to do that?
Well, I don't know exactly.
What kind of bus are you driving?
Well, I would assume that once you decide that there's been a violation, the next step would have to be notifying the accused, would it not?
Give me 1 second here.
Yeah. Maybe if you just had an additional paragraph, the commission may request for opinion, may request any additional information or something like that. Because again, here I'm offensively giving that information. Whereas if basically after they've had some inquiry and had some discussions, and maybe just use that language, any other information that you're, especially again, and any resulting recommendation. Or if you hit, just go, and find period. And upon request by the commission, ethics officer may, right.
All right, I think we've got some sort of workable language here for you all. I think the judge and I are recommending that we remove entirely section 3. And then in section 5, remove any resulting recommendation and make that sentence appropriate. So any other information that the ethics officer deems appropriate and relevant to the preliminary investigation and the finding of that investigation. You know, make it a full sentence as opposed to kind of cutting it off. And then additionally, after that, the Ethics Commission may request a recommendation on any corrective or disciplinary action it should take.
May request.
Basically, the language of number 3.
Right, so we're kind of combining 3 and 5. So the Ethics Commission may request a recommendation for any corrective or disciplinary action it should take.
Okay, there, and I would like to say that in 4, formal complaint will be submitted to the chairman of the commission, but I think that it should be to the commission. not just to the chairman.
Okay, I don't see any
Yeah,
problem with that.
fine.
Yeah, I don't see any problem with that.
So just to the commission and take out chairman of the. Although I like being God. So all right, there's another one up here. And C, upon the conclusion of the preliminary investigation, the ethics advisor shall promptly issue a written summary report and deliver the same to the chairman of the commission. Why only the chairman? Why wouldn't it go to the commission, or you don't want to call a meeting for that, or what?
Better be consistent. And
Yeah.
Judge Wenzelman, you would just put in members of the commission, I guess.
Yeah, I mean, that's the purview of this commission to determine whether it wants information to flow between one individual and the ethics officer or all five. I mean, that's really just a choice.
I just feel the information should be, that it should be sent to the commission, not the chairman of the commission.
And while we're there, the appropriate ultimate jurisdictional authority language is up there also.
Yeah, so we should change that too.
Yeah.
So department
Oh.
head there as well. So I'll
Okay,
I'll run through all the changes that we'll make here in just a second. So we're all on the same
department
page.
head, okay.
All right.
What was the last? The ethics commission may request a recommendation for any corrective?
All right. Let me run through all the changes I think I've written down for this slide. That way we're all on the same page and we have the language. So at the beginning, remove chairman of, so that all 5 members of the commission will receive any investigation report
Right,
from the ethics
right.
officer. The appropriate ultimate jurisdiction will be replaced by the appropriate department head.
Right,
Number 3 under C will be taken out completely. And number 5 shall be changed to any other information that the ethics officer deems appropriate and relevant to the preliminary investigation and his or her finding. And a new sentence following that one. The Ethics Commission may request the ethics officer for a recommendation for any corrective or disciplinary action it should take. That puts the onus on the commission to request a recommendation as opposed to a requirement that the ethics officer provide one.
all right, do all the members understand the changes?
Yes.
To move to accept?
I'll move that we accept the changes.
Dr. Dakey, and a second
Second.
from Mr. Coy. All those in favor? Aye. Opposed? Aye. All right. You may proceed, sir.
Now you just have a laugh. All right. Section D, I didn't have anything for. It seems like Judge Wenzelman circled something though.
Appropriate ultimate
Oh,
jurisdictional.
it's in there as well.
Okay.
So let's change that to appropriate department head as
And
well.
promptly notify the chairman of the commission?
Is that in there somewhere as well? Where is
The
that?
commission?
Okay.
That's up there.
So, would a motion be in order to remove the chairman of and change ultimate jurisdiction authority to department?
I move we remove the chairman of.
Hey, if you want to remove yourself, you go right ahead.
And we need a second.
I'll second.
Mr. Blanchett will second. All those in favor? Aye.
Aye.
Opposed? No. All right, we may move on.
All right, subsection E.
Same thing.
Same story, yes.
Okay. All right, I move those changes be made by the attorney. Second?
I'll second it.
Dr. Dakey seconds. All those in favor?
Aye.
Aye, aye. Okay. Any other discussion? And we can move on.
Moving on to F.
to section F.
I'd imagine we have the same conversation in here somewhere, but let's take a look. Ultimate jurisdictional authority in subsection 2 and 1, both. I did make a,
Oh, gee, remove the U.
right, move the U, yeah. For whatever reason it says cause, not case.
Although I move those changes be made. Second? Second? Oh, Mr. Coy made the second. All those in favor?
Aye.
Did you have anything else? You good?
Any other discussion? If not, we can move to hearing procedure by Ethics Commission.
This is Don Dakey. A question, to have us meet and take jurisdiction, do we need just a quorum?
Yes,
Okay, so it'd be 3 of 5.
3 of 5, yep.
Okay.
And I think that concern right there is why we upped it to 5 and not 3.
Right. Okay. And should Toby be indisposed by being in Mexico or something, I want to make sure we can still move on.
No, I think we should have the hearing in Mexico.
Okay.
Okay, any other discussions? We can move on. Section D.
So this one, I did add with the assistance of legal counsel. The reasoning behind that is Judge Wenzelman's concerns about prosecuting a case and practicing law. Our recommendation is with the assistance of legal counsel only for that reason. He would of course be around.
What does pro se mean?
Pro se means the individual can basically carry their own case without the assistance of legal counsel if they so choose. They have every right to do that on their own without assistance.
Shall we move to accept that change?
Second.
I moved and Mr. Coy second. All those in favor?
Aye.
All right, we can move on to 259 Ethics Commission decisions and reconsideration. No changes?
I did not make any suggested changes, no.
All right. Let's go on to section C then, or paragraph C.
Has everyone had a chance to review 259? I don't want to make sure we're moving too fast. It does have the ultimate jurisdictional authority in section B, if we want to change that to department head like we've been doing.
So is it saying here in B that if the department head, if the complainant considers the department head's decisions too tough, he can come back to us? He or she can come back to us to reconsider?
Correct.
Okay.
Right.
All right, I move that we take those changes, the one change, department head.
Second.
Dr. Dakey seconds. All in favor?
Aye.
Okay. No changes, you made no changes?
I did not suggest any changes, no.
Okay. And we can, if no one has any discussion on that particular section, we'll go on to section 260, recommendations for discipline.
Okay, Judge Wenzelman, again, this is where we have to change the language a little bit since we changed as to whether or not we're going to make a, we took out where I was going to make a recommendation for resolution other than a formal complaint. Although I guess that still would be an option.
They would ask for it, but
Yeah, if they have to ask for the information, but it still would be an option. Okay, so yeah, I guess that could stay in that way.
Other than an E, there's no changes in that?
right.
I thought maybe that was a legal term I didn't
No,
Yeah.
no. I have the same problem with county board resolutions. For whatever reason, Word doesn't like it when you put it in the title. It doesn't. It doesn't trigger it for some reason. Maybe it's just my program for some reason.
All right,
Yes.
if there are no further discussions on this particular page, we'll go to 260 continued. We have ultimate jurisdictional authority.
In several places,
Yes.
I count
Let's just make
an omnibus motion for that.
overall
So move.
move that we just change it wherever it shows up.
Fair enough.
Second,
Second.
Coy. All in favor?
All right.
All right, easy enough. Done.
Okay. So if there are no other questions or discussions, we can move on to collective bargaining restriction. There is a change in that. From which this section is derived, which we don't know where it's derived from.
And that's why I recommend taking it out. I don't know
Okay.
where that language came from. For whatever
Okay.
reason, it snuck its way into the ordinance. That's just to clean it up.
And so any collective bargaining that goes on after this date or whenever we prove this,
Well, this
Has
language
to-
is already in our ordinance. So
okay,
in theory, I remember the jokes made about this, but in theory, it should be a part of any collective agreements moving forward.
okay. So we want to move to approve the, from which this section is derived,
As
Right.
this one's already in my PowerPoint, we can discuss that at the end. Remember, we're going to change things
Oh,
throughout. We can do the
okay.
vote, but otherwise, at the end, we can collectively approve all my changes and the ones we've already approved.
all right, and we can go to administrative review.
I made no recommendations in this one. The judge hasn't scribbled anything either, so I'm assuming he's okay.
So the decision of
It
the
could be that too.
commission to dismiss a complaint, not the complainant, they're not talking about the person losing their job. But the fact that we say we don't want to hear a complaint, is that what that's referring to? It's not subject to the administrative review under the Illinois Code of Civil Procedure?
Right, so this would be a personal or subject matter jurisdiction decision by the ethics officer. For whatever reason, he or she does not think you have the authority to hear it. It's kind of his recommendation, or his or her recommendation, and we move on from there.
And that's a recommendation he makes to the commission? 'Cause
Correct,
it's the
correct.
decision of the
And the commission would have to obviously accept that
Yeah.
or reject that recommendation, yes.
All right, if there's no further discussion on that, we'll move on. Generally. Generally speaking,
Well, I think this was the title of the code in our code says whistleblower. What's phrased? Do you have it there? Whistleblower something. Whistleblower protection, I think is how it's phrased.
Protection Act.
For whatever reason, the subsection that all the meat is says generally.
generally.
It's just a copy
Okay.
and paste thing, but it is the whistleblower part of our ordinance.
And did you add or remove or change what?
Whistleblower Protection Division.
Ethics officer, the auditor, or the employees
So I added
department?
the ethics officer instead of, and I took out state's
Okay.
attorney. Because for whatever reason, our whistleblower reference could go to our state's attorney, and I think that was probably a carryover from when the state's attorney was the ethics advisor. Now I've switched that out.
Any other discussion here of this section?
This is where I wanted to have a more in-depth conversation regarding Judge Wenzelman's concerns about what the ordinance in your jurisdiction covers. I think this language, by implication, opens it up from just gift ban, and help me with the other one. Gift ban and
Political activity.
political activity. Beyond that, to anything that would be covered by the whistleblower protections, so harassment or bullying or anything like
Right.
loads of things would fall into that caveat. I don't know where the judge stands on whether that language would be sufficient or not, but I think you're covered and have a lot more to talk about than just those two things based on this change. Do you have any input there? The judge,
Unless, is there again, Judge Winsman, and I don't have necessarily that section in front of me, but the powers of the commission, does it specifically say, a certain, I guess if it makes reference to a couple of those two sections, the gift ban and political activity, if that's where, is there a way to just reference this, Division 7 in there? And that's why I can't remember off the top of my head here.
This one talks about someone in the office making a complaint against somebody else. Is that what that?
I'm sorry, Madam Chairman. What are you asking? Sorry.
In section A.
Yeah.
Okay. Whenever any officer or employee of Kankakee County reasonably believes evidence exists, so they can come and complain. Is that what this
Correct.
is?
So
Yeah. They would fill out a.
they're not required to do so. If they choose the commission route, of course, they would have to go through the process we've already been through today, with filing a complaint and all that.
Okay.
If they choose to go to the department head or the auditor, there are statutory reasons for having that language in there as well. They can handle it that route in addition to this route. So it's up to the employee or the officer how they want to proceed and get their issues addressed, whether they feel it's appropriate to come here or just kind of handle it. Hang on a minute, should we be spending this money? Would be an auditor thing, or what's going on here? Address it in house to make sure they have a
Okay.
appropriate concern first, or if they feel like for whatever reason they can't do that, then they can come here.
In-house or to the.
Correct. So
Okay.
the way this envisions is obviously things happen on a daily basis that not every single employee in any one specific department has the full picture. If they feel something's going on to the point where they feel a criminal act is occurring, or they don't feel comfortable going to the department head, that would be harassment or for whatever reason, bullying, that kind of thing. You're able to hear those complaints and address it. But if they feel it's okay to go to the department head and maybe get the whole picture, or at least have their concerns addressed, it's not required to come here and only hear it, right?
Okay.
This is a Don Dakey question. To what degree will county employees be informed of this ordinance? I mean, other than it's on the books, does this get passed through department heads to notify them? Because would they even know this exists?
So we're not sitting down with each individual employee and,
Right.
and explaining that would be too arduous. However, it is addressed presumably monthly. I'm actually not party to department head meetings, but it is discussed at length in those meetings regularly. And also the county is also passing changes to its county handbook pretty much as we speak. That's a process we're going through now. And any changes to department policy would have to be addressed
Okay.
to employees. And one of the substantive changes throughout our handbook is references to the commission, what to do in the event of something that is inappropriate, those kind of concerns.
Right. Thank you.
So hopefully that message does get out. I can't guarantee every
Right.
employee, but
Right.
we're trying our best to make sure employees are aware of this.
So this discussion about whistleblower and
Did you find it?
covering other things, where is that included?
The judge found it, so I'm going to let the
Okay.
judge speak to it.
Okay, if you go back to section, and it's not gonna be in your handout there, but section 2-255, powers and duties, limited. That's the powers and duties of the commission. And it makes specific reference to the Division 2, political activity, Division 3, which is gift ban. So my suggestion would be to add Division 7, which is,
You're in one more slide forward.
Powers and duties limited.
Give me one more, Dan. 7.
2-255.
The back
One
one,
more back there.
right,
There.
There,
that what you're-
okay,
okay.
so yeah, so you've got reference in there to, the Division 2, which is political activity, Division 3, which is,
Oh, I see what you're saying.
the gift ban, if you just added Division 7, which is the whistleblower protection. And that way it's specifically listed as being under the jurisdiction of.
Yeah, that's an appropriate
Commission.
change. Yep.
I'm sorry, I cannot find that.
So
You got, Division 2, which is.
that's the gift ban, I
gift
believe.
ban. Division 3 is,
Prohibited political activity.
correct.
Oh, that's not listed in here.
And what the judge is saying is he would recommend the addition, and I would agree with this, to add Division 7, which is the whistleblower protections we were just talking about.
So that way
Just
you
to
have
make sure
specifically-
everything's covered.
Okay, but for violations of Division 2,
Division 2 is gift ban,
how do we know that?
because that's how it's referenced in our ordinance.
Where does it say? I don't.
Sorry.
I'm sorry.
Do you have it? I'll approach with it.
Division. Okay, there's, gift ban in Division 3, so I assume right in front of it is the
Okay,
other one.
just help me.
So I can explain it to everybody. This is our full and complete ordinance, right?
Oh, okay,
It's split up into 7 divisions currently.
okay.
Division 1 just is the definitions. Division 2, which is what the judge is referencing here, is prohibited political activities. So that is one. No, because we were not discussing changing this,
Okay.
but by extension we are referencing that. So Division 2 is prohibited political activities, which you have jurisdiction over right now, as we sit, regardless. Division 3 is gift bans, so you can't bribe me to not prosecute a case, kind of stuff, right? And Division 7 is what we're discussing right now with regards to whistleblower protections.
Okay.
So what the judge and I are recommending is we just make reference to Division 7 as well as those 2 other divisions. That way it's full circle, everyone's clear about what your jurisdiction is.
Thank you very much. So we need a motion to add Division 7 whistleblower to Section 2, Powers and Duties Limited.
Correct.
Okay.
So take out the or, add it to the end of Division 3 and say or Division 7.
Okay.
You know, make the,
Second
make
on that?
sound right.
Second.
Coy? Mr. Coy seconded? I can. All in favor?
Aye.
Aye. Okay.
Alright, so I think we're back on the second to last slide, Diane. 2-286 generally.
Yes.
Whoa, too far. There you go. Anything else?
I think we did generally. We need to go
Well,
to
that's
the next
this
page.
is where I wanted to have the conversation about opening up the commission's jurisdiction. I think we've addressed that. I want to make sure I covered the judge's thoughts
Oh.
too. So
Okay.
I think you can go to the next slide, Diane. There you go. So I didn't make any substantive changes here, but now I think we've covered the jurisdiction of this part of the statute or the ordinance. So
Yep, nothing more.
So-
that kind of concludes my recommendations. If there's anything else you want to discuss, now would be the time. Anything we haven't talked about, we can always go back. Otherwise, what I would recommend is make a motion to make all the suggested changes as outlined in the PowerPoint, plus the ones we've done along the way, just to cover it, make sure we're procedurally correct, and go from there.
Steve Coy, I'll make the motion to amend the changes as recommended, as approved by the.
I will second it.
Dr. Dakey second. Mr. Coy made the motion. All in favor?
Aye.
Aye.
All right.
I think that
Is there any other part of the ordinances that we want to discuss? While we have it on the agenda and you have both Judge and I here to discuss it. All right. Just on a personal note, I do want to say I appreciate your patience with me these past few months. For what I hope are obvious reasons, I've tried to take a step back. But that doesn't mean I wasn't paying attention or trying to address your concerns. It just means I didn't feel appropriate to be in the room. So with that, I think you can move on to the agenda.
Okay, very good. And the, section 7, item 7, I should say, old business, new business. None? Then unless anyone has any, Dr. Dickey, you have anything to
I
say?
do not.
Steve Coy?
Motion to adjourn.
Mr. Blanchett?
Second the motion.
Okay. All those in favor?
Aye.
Very good.